The moment I saw those 3 black SUVs pulling up my gravel driveway at 7 in the morning, briefcases in hand and suits that cost more than most people's monthly rent, I knew trouble had found its way to my quiet corner of Texas Hill Country. What I didn't expect was for them to wave around legal documents claiming ownership of my century-old family pond, citing water access laws that I helped write 30 years ago. As I watched their confident smirks fade when I introduced myself as the co-author of the very statute they were butchering, one thought crossed my mind. How many other ranchers had they bulldozed with their twisted interpretation of my own legislation? Before we carry on, please hit the subscribe button to make my day and let me know where you are watching from in the comments. I've been Miguel Contreras for 68 years, and for the last 8 of those, I've been trying to enjoy my retirement on the 300-acre ranch that's been in my family since 1897. My great-grandfather, Joaquin Contreras, bought this land when it was nothing but scrub brush and rattlesnakes, but he saw something in the natural spring that fed into what would become our family pond. That spring never ran dry, not even during the worst droughts Texas had seen, and over the generations, we built our lives around that steady source of water. The pond itself covers about 2 acres, surrounded by old mesquite trees and bordered by the stone retaining wall my grandfather built with his own hands during the Great Depression. It's not just water to us, it's history, it's livelihood, it's the heart of everything we've worked for. My cattle depend on it, the wildlife that calls this place home depends on it, and frankly, my sanity depends on the peace I find sitting on its banks every evening with my coffee and my memories. I spent 35 years as a water rights attorney for the state of Texas, specializing in rural and agricultural water law. I wasn't just any lawyer. I was the lawyer they called when things got complicated, when century-old claims conflicted with modern development, when federal regulations bumped up against state sovereignty. In 1993, I co-authored the Texas Rural Water Access and Preservation Act with my colleague Sarah Martinez, a piece of legislation designed to protect small farmers and ranchers from exactly the kind of legal bullying I was about to experience firsthand. That Tuesday morning started like any other. I was feeding my 12 head of cattle, checking the fence line, and planning to spend the afternoon replacing some rotted fence posts near the pond. The sun was just starting to burn off the morning dew when I heard the rumble of multiple vehicles coming down my drive. Living out here, you don't get many visitors, and you certainly don't get convoys of expensive cars arriving unannounced. The lead vehicle was a black Cadillac Escalade, followed by 2 matching Suburbans. They parked in a precise formation in front of my house, like they were preparing for some kind of military operation. 6 people emerged, all dressed in business attire that looked completely out of place against the rural backdrop of my ranch. The leader of the group was a woman in her 40s, blonde hair pulled back in a severe bun, wearing a navy blue power suit and carrying a leather briefcase that probably cost more than my monthly grocery budget. She introduced herself as Patricia Hamilton, representing the Whispering Oaks Homeowners Association. Behind her stood 2 men in identical gray suits who looked like they'd rather be anywhere else, and 3 other people who appeared to be a mix of legal assistants and what I assumed were local officials. "Mr. Contreras," Patricia said, her voice carrying the kind of artificial authority that comes from years of pushing people around in subdivision meetings, "we're here regarding your pond and the water rights associated with your property." I set down the feed bucket I'd been carrying and crossed my arms. At 68, I've learned to read people pretty quickly, and this woman had trouble written all over her. "What about my pond?" She opened her briefcase with theatrical flair and pulled out a thick stack of papers. According to Texas Statute 25-37-12 of the Rural Water Access and Preservation Act, any natural water source exceeding 1 acre in size within 5 miles of a residential development must be made available for community recreational use during designated hours. I felt my eyebrows rise involuntarily. 25-37-12 was indeed part of the act I'd co-authored, but she was quoting it completely out of context. That particular section dealt with abandoned or unused water sources on commercial properties, not active agricultural water sources on private land. "Is that so?" I said, keeping my voice neutral. "And what exactly does that mean for me?" One of the gray-suited men stepped forward and handed me another set of papers. These are the access agreements you'll need to sign, permitting members of our community to use your pond for fishing, swimming, and boating activities between the hours of 8 a.m. and 6 p.m. on weekends and holidays. I took the papers but didn't look at them immediately. Instead, I studied the faces of the people standing in my yard. Patricia had the confident look of someone who'd done this before, someone who was used to intimidating rural landowners with legal language they didn't understand. The two men behind her looked uncomfortable, like they knew something wasn't quite right but were following orders anyway. "And if I refuse to sign these agreements?" I asked. Patricia's smile turned cold. "Then we'll be forced to initiate eminent domain proceedings for the public good. The county has already been notified of the potential need to acquire this water source for community use." That's when I realized this wasn't just about my pond. This was about power, about money, and about a systematic attempt to seize private property using twisted interpretations of laws designed to protect exactly the opposite. I'd seen this kind of legal bullying before, but I'd never been on the receiving end of it. "I see," I said, finally glancing down at the papers in my hand. "And you're citing the Rural Water Access and Preservation Act as your authority for this action?" "That's correct," Patricia said, her confidence growing. "The law is very clear on this matter, Mr. Contreras. We're simply ensuring compliance with state regulations." I couldn't help but smile a little. "You know, I'm familiar with that particular piece of legislation." "I'm sure you are," she said dismissively. "But being familiar with a law and understanding its legal implications are two very different things. That's why we have trained legal professionals to handle these matters." "Trained legal professionals," I repeated, nodding slowly. "That's interesting. Tell me, Patricia, what's your legal background?" For the first time, her confidence flickered slightly. "I have a business degree and extensive experience in property management and homeowners association governance, but no law degree. The legal aspects are being handled by our contracted attorneys," one of the gray-suited men interjected. "I'm Robert Klein from Klein, Stevens, and Associates. We specialize in property acquisition and municipal law." I turned my attention to him. "And you're confident in your interpretation of Section 25-37-12? "Absolutely," he said, though I noticed a slight hesitation in his voice. "The statute is quite clear. Clear enough that you're willing to stake your professional reputation on it?" Now both Klein and Patricia were looking less comfortable. "Mr. Contreras," Patricia said, "we didn't come here to debate legal theory. We came here to inform you of your obligations under state law and to secure your cooperation in compliance." I folded the papers and tucked them into my shirt pocket. "Well, I appreciate you bringing this to my attention. Give me a few days to review these documents and consider my options." "We need an answer today," Patricia said firmly. "The community has already made plans for summer recreational activities, and we can't delay implementation any longer." "I understand your timeline," I said. "But this is my property, and I'm not signing anything until I've had a chance to properly review the legal basis for your claims." Patricia's mask of professional courtesy finally slipped completely. "Mr. Contreras, you can make this easy or difficult, but one way or another, this pond will be made available for community use. The law is on our side, and we have the resources to enforce it." "To enforce it?" "The law," I said quietly, "is a very interesting thing. Sometimes people think they understand it when they really don't." After they left, I sat on my front porch for a long time, reading through their documents and feeling a mixture of anger and amazement at the audacity of their legal interpretation. They had taken Section 25-37-12, which specifically applied to abandoned commercial water sources, and twisted it to apply to active agricultural properties. They had ignored subsection C, which explicitly exempted working ranches and farms. They had completely disregarded the intent of the legislation, which was to prevent water sources from being hoarded by developers while protecting the rights of legitimate agricultural operations. But what bothered me most wasn't their misinterpretation of the law, it was the systematic nature of their approach. This wasn't a mistake or an oversight. This was a deliberate strategy to seize private property using legal intimidation. I wondered how many other ranchers and farmers had received similar visits, how many had signed those agreements out of fear or confusion. How many had lost access to their own water sources because they didn't understand the law well enough to fight back. That evening, I called my old colleague Sarah Martinez, who was now teaching law at the University of Texas. Sarah had been my partner in drafting the Rural Water Access and Preservation Act, and she was one of the few people who understood both the letter and the spirit of the legislation as well as I did. "Miguel," she said when she heard my voice. "It's been too long. How's retirement treating you?" "It was going well until this morning," I said, and then I told her about Patricia Hamilton and her legal team. There was a long silence on the other end of the line. "You're kidding me," Sarah finally said. "They're using our own legislation to steal water rights from ranchers?" "It looks that way, and I have a feeling my place isn't the first one they've targeted." "This is unbelievable," Sarah said. "Miguel, you know that statute better than anyone. Section 25-37-12 doesn't apply to active agricultural operations, and it certainly doesn't give homeowners associations the right to seize private water sources. I know that, and you know that, but how many ranchers out there understand the fine print of water rights law?" Sarah was quiet for a moment. "What are you thinking?" "I'm thinking it's time to come out of retirement." The next morning, I started making phone calls. First, I called the local newspaper, the Hill Country Herald, and asked to speak with investigative reporter Jenny Morrison. Jenny had written several pieces about property rights issues in our area, and I thought she might be interested in this story. "Mr. Contreras," Jenny said when I explained the situation, "this sounds like exactly the kind of thing we've been hearing rumors about. We've had 3 other ranchers contact us in the past 6 months with similar stories, but none of them wanted to go on record." "What kind of stories?" "Homeowners associations claiming water rights to private ponds, developers using environmental regulations to restrict land use. That sort of thing. But if you're willing to go public with this, and if you really co-authored the law they're misusing, that changes everything." "I'm willing to go public," I said. "In fact, I think it's necessary. Can you meet me this afternoon? I'd like to see those documents they gave you, and I'd like to hear the full story." Jenny arrived at my ranch around 2 o'clock, driving a dusty Honda Civic that looked much more at home on my gravel driveway than those black SUVs had. She was a woman in her 30s with short brown hair and the kind of determined expression that told me she took her job seriously. We sat at my kitchen table while I spread out the documents Patricia Hamilton had given me. Jenny photographed each page and took extensive notes as I explained the legal problems with their interpretation. "The key issue," I told her, "is that they're applying a statute designed for abandoned commercial properties to active agricultural operations. It's like using a law about vacant buildings to claim someone's house." "And you're absolutely certain about this?" I got up and went to my study, returning with a thick binder. "This is my personal copy of the complete legislative history of the Rural Water Access and Preservation Act. Every draft, every revision, every committee hearing, every floor debate. Sarah Martinez and I spent 2 years crafting this legislation, and I can tell you exactly what every section was intended to accomplish." Jenny's eyes widened as she flipped through the binder. "This is incredible. Do you mind if I make copies of some of these documents?" "Take whatever you need. But Jenny, I think this story is bigger than just my ranch. I think there's a systematic campaign going on here, and I think other people need to know about it." "What do you mean?" I told her about my suspicion that other ranchers had been targeted, about the professional way Patricia Hamilton and her team had operated, about the resources they seemed to have behind them. "Let me do some digging," Jenny said. "If there are other cases like this, I'll find them." 3 days later, Jenny called me back. "Miguel, you're not going to believe what I found. Try me. In the past 18 months, the Whispering Oaks Homeowners Association has filed water access claims against 7 different properties in 3 counties. 5 of those property owners signed agreements giving the HOA recreational access to their water sources. 2 are still fighting in court. But they don't have the legal expertise to mount an effective defense." End quote. 7 properties, I said. That's not a coincidence. It gets worse. I found out that Patricia Hamilton isn't just the HOA president. She's also a partner in a property development company called Hill Country Estates. They've been buying up land adjacent to these water sources and marketing luxury homes with exclusive access to pristine natural swimming and fishing areas. So they're stealing water rights from ranchers and selling access to those same water sources to wealthy buyers. Exactly. And they're using your own legislation to do it. That afternoon, I made a decision that would change the direction of my retirement permanently. I called a press conference. Jenny helped me contact the major news outlets in Austin and San Antonio, as well as the agricultural newspapers and rural advocacy organizations. I also called the state attorney general's office and the Texas Department of Agriculture, informing them that I had information about systematic abuse of state water rights law. The press conference was scheduled for Friday morning at 10 o'clock, to be held right here on my ranch, next to the pond that had started it all. By Thursday evening, my quiet country road was busy with news vans and reporters. Jenny had done her job well. The story was getting attention throughout the state. Friday morning dawned clear and warm, perfect weather for what I hoped would be a definitive end to Patricia Hamilton's scheme. I had prepared extensively for this moment, gathering all of my legislative documents, consulting with Sarah Martinez about the technical legal points, and even reaching out to 2 of the other ranchers who had been targeted by the HOA. At 10 o'clock sharp, I stood on the stone wall that bordered my family pond, looking out at an audience of about 30 reporters, photographers, and camera crews. Behind them, I could see several of my neighbors who had come to show their support, including old Tom Bradley, whose family had been ranching in this area even longer than mine. "Good morning," I began. "My name is Miguel Contreras, and I've been fighting for water rights in Texas for most of my adult life. 3 days ago, representatives of the Whispering Oaks Homeowners Association came to my ranch, demanded access to this pond, claiming authority under Texas Statute 25-37-12 of the Rural Water Access and Preservation Act." I paused and looked directly into the cameras. What they didn't know is that I co-authored that legislation 30 years ago, and I can tell you with absolute certainty that they are completely misinterpreting the law. A murmur went through the crowd of reporters. I could see people pulling out their phones, probably alerting their editors that this story was bigger than they had expected. The Rural Water Access and Preservation Act was written to protect small farmers and ranchers from exactly this kind of abuse, I continued. Section 25-37-12 specifically applies to abandoned or unused water sources on commercial properties. It has absolutely no application to active agricultural operations like this ranch. I held up the original legislation. This is my personal copy of the complete bill, including all drafts and revisions. I have the meeting notes from every committee hearing, the transcripts from every floor debate, and the correspondence between myself and my co-author, Professor Sarah Martinez, as we crafted this language. "Mr. Contreras," called out a reporter from the Austin American-Statesman, "how many other properties have been affected by this misinterpretation?" Based on investigative reporting by Jenny Morrison of the Hill Country Herald, at least 7 properties in 3 counties have been targeted by this same group using this same false legal theory. 5 ranchers have already signed away their water rights, apparently not understanding that the law was being misrepresented to them. "What's your response to the HOA's claims?" asked another reporter. My response is simple. They're wrong about the law, they're wrong about their authority, and they're engaged in what amounts to legal fraud. No homeowners association has the right to seize private water sources from working ranches, and no amount of legal intimidation changes that fact. At that moment, I noticed a familiar black Escalade pulling up at the back of the crowd. Patricia Hamilton emerged from the vehicle, accompanied by Robert Klein and several other people I didn't recognize. They pushed their way through the reporters until they were standing directly in front of me. "Mr. Contreras," Patricia said loudly, clearly intending for her voice to carry to the microphones, "your interpretation of the law is irrelevant. Our legal team has thoroughly researched this matter, and we stand by our position." The reporters immediately turned their cameras toward her, sensing confrontation. This was exactly what I had hoped would happen. Patricia, I said calmly, I appreciate you joining us this morning. Since you're here, perhaps you'd like to explain to these reporters how you justify applying a statute about abandoned commercial properties to active agricultural operations. The law is clear, she said, though I noticed she was looking less confident than she had 3 days earlier. Any water source exceeding 1 acre within 5 miles of a residential development must be made available for GESI. Community use. That's not what the law says, I replied. Would you like me to read you the actual text? I opened the legislative binder and turned to the relevant page. Section 25-37-12, subsection A. Abandoned or unused water sources on commercial or industrial properties exceeding 1 acre in size and located within 5 miles of CHI. Incorporated residential developments may be designated for community recreational use following appropriate environmental and safety assessments. Subsection C explicitly states, this section shall not apply to active agricultural operations, working ranches, or residential properties with fewer than 50 units. The crowd of reporters was frantically taking notes. Patricia Hamilton's face had gone pale. Furthermore, I continued, subsection D requires that any such designation be approved by both the County Commissioners Court and the State Water Commission, with mandatory input from Agricultural Extension Services and Environmental DE. Protection agencies. Have you obtained these approvals, Patricia? Our legal team has handled all necessary procedures, she said, but her voice lacked conviction. Robert Klein stepped forward. Mr. Contreras, we've researched this matter extensively, and we believe our interpretation is correct. Based on what authority? I asked. What's your experience with agricultural water law? I have 15 years of experience in municipal and property law. But no specialization in agricultural or water rights law? I'm fully qualified to interpret state statutes. Then perhaps you can explain to these reporters why you ignored subsection C of the very statute you're citing? Klein opened his briefcase and pulled out a copy of the law. I watched him flip through the pages, looking increasingly uncomfortable. It appears, he said finally, that there may be some ambiguity in the language that requires further legal review. There's no ambiguity, I said. The language is crystal clear. You ignored the parts of the law that didn't support your client's objectives. By this point, Patricia Hamilton was clearly ready to leave. Mr. Contreras, this matter will be resolved through proper legal channels, not through media spectacle. I agree completely, I said. That's why I've forwarded all of this information to the State Attorney General's office, the Texas Department of Agriculture, and the County District Attorney. I'm sure they'll be very interested in reviewing your proper legal channels. After Patricia Hamilton and her team departed, I spent another 30 minutes answering questions from reporters. The story that emerged from that press conference would run on the front page of newspapers throughout Texas and would eventually be picked up by national news outlets. But the immediate impact was even more significant. Within hours of the press conference, I received calls from 3 of the ranchers who had signed agreements with the Whispering Oaks HOA. They wanted to know if there was a way to void those agreements based on the misrepresentation of the law. I also received a call from the county attorney's office, informing me that they were opening an investigation into the HOA's activities. The state attorney general's office called that afternoon, asking if I would be willing to serve as a consultant on agricultural water rights issues. Most importantly, I received a call from Sarah Martinez. Miguel, she said, I just watched your press conference online. I'm so proud of what you did today. Thanks, Sarah. But I think this is just the beginning. What do you mean? I think it's time for us to take a hard look at how our legislation is being implemented. If it could be twisted this badly by people with enough resources and legal representation, then maybe we need to strengthen the protections for small landowners. Are you suggesting we revise the Rural Water Access and Preservation Act? I'm suggesting we make it foolproof. Over the next 2 weeks? The story continued to develop. The county attorney's investigation revealed that the Whispering Oaks HOA had never obtained the required approvals from either the county Commissioners Court or the State Water Commission. The contracts they had signed with other ranchers were declared void due to misrepresentation of applicable law. More significantly, the investigation uncovered evidence that Patricia Hamilton's development company had been marketing luxury homes with promises of exclusive access to pristine natural water features, while simultaneously claiming that those same water features were subject to community access requirements. The contradiction in Barad. Their marketing materials provided clear evidence of fraudulent intent. Patricia Hamilton resigned as president of the Whispering Oaks HOA, and Hill Country Estates was forced to refund deposits to several prospective homebuyers. Robert Klein was censured by the State Bar Association for failing to properly research applicable law before advising clients. But the most satisfying outcome came 6 weeks after the press conference, when I received a call from the Texas Legislature's Natural Resources Committee. "Mr. Contreras," said Committee Chairman Representative Jake Morrison, "we've been following the news coverage of your situation, and we're concerned about the potential for similar abuses of agricultural water rights law throughout the state." "I share that concern," I said. "We'd like to invite you to serve as a consultant to help us review and strengthen the Rural Water Access and Preservation Act. We want to make sure that the protections you originally intended for small farmers and ranchers are actually enforceable." "I'd be honored to help." And so, at the age of 68, I found myself back in the state capitol, working with a new generation of legislators to strengthen the very law I had helped create 30 years earlier. Sarah Martinez joined me as co-consultant, and together we drafted amendments that would make it much more difficult for unscrupulous developers and homeowners associations to twist water rights law for their own benefit. The revised legislation, which passed unanimously in both houses of the Texas legislature, included several key provisions. First, it established a mandatory consultation process requiring anyone claiming community access rights to private water sources to obtain written approval from Agricultural Extension Services. Second, it created substantial penalties for misrepresenting water rights law, including personal liability for attorneys who fail to properly research applicable statutes. Third, it established a state-funded legal defense fund to help small farmers and ranchers fight spurious water rights claims. Most importantly, the revised law included what became known as the Contreras Clause, which explicitly states that any attempt to claim community access to water sources on working agricultural properties must be reviewed by a panel that includes at least one agricultural water rights attorney and one representative from the affected county's ranching community. On the day the revised legislation was signed into law, I stood once again on the stone wall beside my family pond, this time with Sarah Martinez, Jenny Morrison, and several of the ranchers who had been affected by the acclaimed Whispering Oaks scheme. The pond looked exactly the same as it had 6 months earlier, but everything else had changed. "You know," Sarah said, looking out over the water, "when we first wrote this law 30 years ago, I never imagined we'd have to come back and fix it. I never imagined I'd have to defend my own pond using my own pond legislation," I replied. "But I'm glad we did both." Jenny Morrison, who had won a state journalism award for her coverage of the story, was documenting our conversation for a follow-up article. "Mr. Contreras, what advice would you give to other landowners who might face similar challenges?" "Know your rights," I said. "Don't be intimidated by people in expensive suits carrying official-looking documents. And remember that the law is supposed to protect honest people, not enable dishonest ones." Tom Bradley, my neighbor who had supported me throughout the entire process, raised a beer bottle in a toast. "Here's to Miguel," he said, "for proving that sometimes the good guys really do win." As the sun set over the Texas hill country that evening, I reflected on the strange turn my retirement had taken. I had planned to spend my golden years quietly tending my cattle and enjoying the peace of my family land. Instead, I had found myself at the center of a statewide battle over property rights and legal accountability. But as I watched the last light fade over the pond that had been the catalyst for everything, I realized that this experience had given me something I hadn't expected to find in retirement: a sense of purpose and the satisfaction of knowing that the work I had begun 30 years earlier was now stronger and more protective than ever. The next morning, I received a letter from a rancher in East Texas who was facing a similar challenge from a different homeowners association. He had read about my case in the newspaper and wanted to know if the new legal protections would apply to his situation. I smiled as I reached for my phone to call him back. Retirement, it seemed, would have to wait a little longer. 3 months later, I was sitting in my study, reviewing another case involving water rights disputes, when I heard the familiar sound of vehicles coming up my driveway. For a moment, my heart rate quickened, thinking that perhaps Patricia Hamilton had returned with a new legal strategy. But these weren't black SUVs. Instead, a small convoy of pickup trucks and ranch vehicles was approaching my house. As they parked, I recognized several faces: Tom Bradley, the rancher from East Texas I had helped, Jenny Morrison, and about a dozen other people I had met during the legislative process. Sarah Martinez got out of the lead truck, carrying what appeared to be a large framed document. "Miguel," she called out, "we have something for you." I walked out onto my front porch as the group gathered in my yard. Sarah held up the frame, and I could see that it contained the original copy of the Rural Water Access and Preservation Act, along with the amendments we had recently passed. "This is a gift from the Texas Ranchers Association," Sarah said, "in recognition of your defense of agricultural water rights and your service to rural communities throughout the state." But that wasn't all. Tom Bradley stepped forward with a second frame. "This is from all of us who were helped by what you did," he said. The second frame contained a photograph of my pond, taken during the press conference, along with a plaque that read, "The Contreras Pond, where one man's knowledge of the law protected every rancher's right to their land." As I looked at the faces of these people, farmers and ranchers and journalists and legislators who had come together to support the principle that the law should protect honest folks rather than enable dishonest schemes, I realized that the pond behind me had become more than just a water source for my cattle or a quiet place for my evening coffee. It had become a symbol of the idea that knowledge is power, that understanding your rights is the first step in protecting them, and that sometimes, when the chips are down and the expensive suits come calling, an old retired lawyer with a pond and a principle can make all the difference in the world. That evening, after everyone had gone home, I sat on my usual spot by the pond with my coffee and my memories. The water was still and clear, reflecting the first stars of the evening. My cattle were settled for the night, the fence posts were all secure, and the world was quiet again. But I knew that quiet was deceptive. Somewhere out there, another Patricia Hamilton was probably preparing another scheme to take advantage of people who didn't know their rights. Another Robert Klein was probably misreading a statute and preparing to intimidate someone who couldn't afford to fight back. And I knew that as long as that was true, my retirement would never really be complete. There would always be another rancher who needed help, another law that needed defending, another pond that needed protecting. I took a sip of my coffee and smiled. After 35 years as a water rights attorney and 6 months as an accidental activist, I had finally figured out what I wanted to be when I grew up. A guardian of the principle that the law belongs to everyone, not just to people with expensive briefcases and black SUVs. The pond rippled gently in the evening breeze, and I could hear the distant sound of my cattle settling in for the night. Somewhere in the darkness, an owl called out, and another answered from across the water. It was good to be home, and it was good to know that home was safe, not just for me, but for every other rancher who might face the same challenge I had faced. The law I had helped write 30 years ago was stronger now, and the precedent we had set would protect other families for generations to come. As I stood up to head inside, I looked back at the pond one more time. Tomorrow, I would probably get another call from another rancher, facing another challenge. And I would answer that call, because that's what you do when you have the knowledge and the experience to help. But tonight, I was just a retired man with a pond and a story, grateful for the chance to prove that sometimes, knowledge really is the most powerful weapon of all. 6 months had passed since the legislative victory, and my life had settled into a new rhythm that balanced the peaceful solitude of ranch work with the intellectual challenges of consulting on water rights cases. Across Texas. The phone calls came regularly now, sometimes 3 or 4 a week, from farmers and ranchers who had heard about my case and needed guidance navigating the increasingly complex world of rural property law. On a crisp October morning, I was replacing a section of wooden fence near the back pasture when my cell phone rang. The caller ID showed a number I didn't recognize, with a 214 area code that placed it somewhere in the Dallas Metroplex. "Mr. Contreras," said a woman's voice, strained with worry. "My name is Elena Vasquez. I got your number from the Texas Ranchers Association. I think I need your help." I set down my hammer and gave her my full attention. "What's the situation, Elena?" "There's a company called Metropolitan Water Solutions that's trying to take our family well. They say they have the right to drill on our KT property because of some federal environmental regulation about groundwater management. They're threatening to sue us if we don't give them access." This was a new twist. Most of the cases I'd been consulted on involved surface water disputes. But groundwater rights were an entirely different area of law, governed by a complex mix of state regulations, federal environmental rules, and historical precedent dating back to Spanish colonial land grants. "How long has your family owned the property?" I asked. "Since 1908. My great-grandfather bought 40 acres outside Garland when it was nothing but cotton fields. We've had the same well for over 80 years. And this Metropolitan Water Solutions, what exactly are they claiming?" Elena's voice grew more agitated. "They say that because our well produces more than 50 gallons per minute, it falls under some federal aquifer protection program. They want to install monitoring equipment and restrict when we can pump water. But, Mr. Contreras, this is our only water source. We have 12 horses, a vegetable garden that feeds half the neighborhood, and my elderly mother depends on this place." I knew immediately that something was wrong with their legal theory. Federal aquifer protection programs typically applied to large commercial operations or municipal water systems, not family wells on small rural properties. But I also knew that unscrupulous companies had gotten very creative about finding ways to exploit environmental regulations for profit. "Elena, I'm going to need to see the documents they gave you. Can you email them to me?" "I don't have email," she said. "I'm 73 years old, and computers aren't my strong suit." "That's fine. Can you fax them, or would you prefer if I drove up to meet with you?" "Would you really do that? I can pay you for your time." "Don't worry about payment right now. Let's focus on understanding what we're dealing with. I can be there tomorrow afternoon if that works for you." The drive to Garland took me through some of the most rapidly changing landscape in Texas. What had once been rural farming communities were now suburban sprawl, with strip malls and housing developments stretching as far as the eye could see. But as I followed Elena's directions off the main highway, I found myself on a narrow country road that seemed to have escaped the march of progress. Elena's property was a green oasis surrounded by new construction. Her 40 acres included a modest farmhouse built in the 1920s, several outbuildings that had clearly been maintained with care over the decades, and pastures where a dozen horses grazed peacefully. The contrast with the cookie-cutter subdivisions visible in the distance was striking. Elena met me at her front gate, a small woman with silver hair and calloused hands that spoke of a lifetime of hard work. Despite her age, her handshake was firm, and her eyes held the same determined look I'd seen in mirrors for most of my career. "Mr. Contreras, thank you for coming all this way. I wasn't sure who else to call." "You called the right person," I said. "Now, let's see what we're dealing with." We sat at her kitchen table while she spread out the documents Metropolitan Water Solutions had delivered. As I read through their legal claims, I felt the familiar anger that came with recognizing a sophisticated scam designed to prey on people who didn't have the resources to fight back. "Elena," I said after reviewing the papers, "I have good news and bad news. The good news is that their legal claims are completely baseless. The bad news is that they're counting on you not knowing that." "What do you mean?" I pointed to the federal regulation they were citing. This is the Safe Drinking Water Act, specifically the section dealing with public water systems. It has absolutely no application to private wells on residential property. They're trying to scare you with official-sounding language that doesn't actually give them any authority over your well. Elena's relief was visible. "So they can't force us to let them onto our property?" "Not under the law they're citing. But Elena, I suspect this isn't really about water regulations. Let me ask you something. Have you had any developers approach you about selling your land?" Her expression darkened. How did you know? About 6 months ago, a man from some big real estate company offered to buy the property. When I told him it wasn't for sale, he said it would be sold one way or another because this area was designated for high density residential development. And now, mysteriously, you have a water company claiming your well violates federal regulations. You think they're connected? I think we need to find out. Do you remember the name of the real estate company? Elena got up and retrieved a business card from a drawer. Premier Land Acquisition, she said, handing me the card. The man's name was David Chen. I photographed the business card with my phone and made a note to research Premier Land Acquisition when I got home. But first, I wanted to understand more about Metropolitan Water Solutions and their supposed authority to regulate private wells. Elena, when these people came to your door, did they show you any official credentials? Government identification? Regulatory authority? Anything like that? They had fancy business cards and official-looking documents, but now that you mention it, I don't think they ever claimed to be government employees. They just said they were authorized to enforce federal water regulations. This was a common tactic among companies that specialized in legal intimidation. They would use language that implied government authority without actually claiming it, knowing that most people wouldn't ask for clarification. It was fraudulent, but it was also effective against people who didn't understand their rights. Here's what we're going to do, I said. I'm going to research both of these companies and find out exactly who we're dealing with. In the meantime, don't sign anything, don't give them access to your property, and don't let them intimidate you. Your well is legally protected, and they have no authority to interfere with it. But what if they sue us like they threatened? Elena, let them try. I've been dealing with water rights law for 40 years, and I can tell you with complete confidence that they don't have a legal leg to stand on. More importantly, if they do try to file a frivolous lawsuit, they'll be exposed to sanctions and penalties that could cost them a lot more than they're hoping to gain. End quote. The drive back to my ranch gave me time to think about the patterns I was seeing. The Whispering Oaks case had involved a homeowners association using twisted interpretations of state law to seize surface water rights. Now, I was seeing a private company using misrepresented federal regulations to target groundwater rights. In both cases, the ultimate goal seemed to be forcing landowners off their property for the benefit of developers. That evening, I spent several hours researching Metropolitan Water Solutions and Premier Land Acquisition. What I found confirmed my suspicions and opened up a much larger picture of coordinated property acquisition schemes throughout the Dallas-Fort Worth Metroplex. Metropolitan Water Solutions was a subsidiary of a larger company called Environmental Compliance Partners, which specialized in what they euphemistically called regulatory facilitation services. Their website was full of vague language about helping property owners comply with complex environmental regulations, but when I dug deeper into their corporate filings, I found connections to several major Bay Area real estate development companies. Premier Land Acquisition was even more interesting. According to public records, they had acquired over 2,000 acres of formerly rural land in the past 3 years. Most of it through purchases from elderly landowners who had been convinced that environmental regulations would make their property worthless. The pattern was clear. Metropolitan Water Solutions would claim that a property was in violation of federal regulations. Premier Land Acquisition would swoop in with a low-ball offer that seemed like the landowner's only option, and the property would be flipped to major developers for massive profits. But the most disturbing discovery came when I cross-referenced the addresses of properties that had been acquired by Premier Land Acquisition with a map of proposed high-speed rail routes through North Texas. Every single property they had acquired was either directly in the path of the proposed rail line or adjacent to planned stations. Someone with inside information about the rail project was using that knowledge to systematically acquire land that would become extremely valuable once the project was announced publicly. This wasn't just fraud, it was potentially insider trading and conspiracy to manipulate real estate markets using non-public government information. The next morning, I called Elena with an update on my research and a plan for moving forward. Elena, the situation is more serious than I initially thought, but also more winnable. These people are running a sophisticated land acquisition scheme, and your property isn't the only one being targeted. What does that mean for us? It means we're not just going to defend your well, we're going to shut down their entire operation. But I'm going to need your permission to involve some additional people in this case. What kind of people? Law enforcement. What they're doing isn't just unethical, it's criminal. I want to contact the FBI's white-collar crime unit and the Texas Attorney General's office. Elena was quiet for a moment. Mr. Contreras, I'm an old woman who just wants to be left alone to take care of my horses. I don't know if I'm up for fighting the FBI and big corporations. You won't be fighting them, Elena. They'll be fighting for you. And you won't be alone. I suspect there are dozens of families who have been victimized by this scheme, and once we expose it, they'll want justice too. Will my mother and I be safe? These people seemed very determined. I'll make sure you're protected. And Elena? Once this story comes out, they'll be too busy dealing with federal investigators to bother with intimidating anyone. 3 days later, I was sitting in a conference room in downtown Dallas with FBI Special Agent Maria Santos, Texas Attorney General Investigator James Patterson, and Assistant District Attorney Lisa Chang. Elena had agreed to press charges, and I had provided them with all of my research on metropolitan water solutions and premier land acquisition. Mr. Contreras, Agent Santos said, this information is extremely valuable. We've been investigating similar schemes in other parts of Texas, but we hadn't connected them to the high-speed rail project. How many other victims are we talking about? I asked. Based on what you've given us, potentially hundreds. We're going to need to move quickly before they realize we're onto them. James Patterson, the Attorney General's investigator, opened the thick file. We've had complaints about environmental compliance partners in Austin, Houston, and El Paso. They use different subsidiary names in different cities, but the pattern is always the same. They claim federal environmental violations, then their partner companies offer to buy the property at below market prices. What's the next step? I asked. We're going to set up a sting operation, Agent Santos said. We want you to contact Metropolitan Water Solutions and arrange a meeting. We'll record the conversation and get them to admit their scheme on tape. The plan was simple but risky. I would call Metropolitan Water Solutions, identify myself as Elena's attorney, and demand a meeting to discuss their claims about her well. The FBI would wire me for sound and position surveillance teams around the meeting location. If everything went according to plan, we would have recorded evidence of fraud and conspiracy. 2 days later, I found myself sitting in a Starbucks in Plano, wearing a wire and waiting for representatives from Metropolitan Water Solutions to arrive. Agent Santos and her team were positioned around the coffee shop, disguised as customers and employees. At exactly 2 o'clock, 2 men in expensive suits entered the coffee shop and approached my table. The first was tall and thin, with prematurely gray hair, while the second was shorter and stockier with the kind of aggressive demeanor that suggested he was used to intimidating people. Mr. Contreras? The tall man said. I'm Richard Walsh from Metropolitan Water Solutions, and this is my associate, Kevin Murphy. Gentlemen, I said, standing to shake their hands. Thank you for agreeing to meet with me. We sat down, and Walsh immediately pulled out a tablet computer. I understand you're representing Elena Vasquez in the matter of her well compliance issues. That's correct. I've reviewed your documentation, and I have some concerns about your legal authority in this matter. Walsh's expression didn't change, but Murphy leaned forward aggressively. Look, counselor, we're not here to debate legal theory. Your client is in violation of federal water quality regulations, and she needs to comply or face the consequences. What consequences, specifically? Federal fines, property liens, and ultimately seizure of the property if she continues to operate an unregulated water extraction facility. I had to admire their audacity. They were completely fabricating federal authority that didn't exist, but they were doing it with such confidence that most people would be terrified. I see, I said. And if Mrs. Vasquez were to decide that compliance was too expensive and she wanted to sell the property instead, would your company be able to recommend a buyer? Walsh and Murphy exchanged a look. Well, Walsh said slowly, we do work with companies that specialize in acquiring properties with environmental compliance issues. Companies like Premier Land Acquisition? Now both men looked uncomfortable. I'm not sure what you're implying, Mr. Contreras. I'm not implying anything. I'm asking directly. Do you have a business relationship with Premier Land Acquisition? Murphy's aggressive demeanor kicked into high gear. That's none of your business. Our job is water compliance, not real estate. But it would be convenient if families facing expensive compliance costs had an easy way to sell their property, wouldn't it? Mr. Contreras? Walsh said, I think this meeting is getting off track. Your client has 30 days to begin compliance procedures, or will be forced to initiate enforcement action. What kind of enforcement action? Federal marshals, property seizure, the full weight of environmental protection law. This was exactly what the FBI had hoped to hear. They were explicitly claiming federal authority they didn't possess and threatening actions they had no power to take. Gentlemen, I said, before we go any further, I think there's something you should know about me. What's that? I'm a retired water rights attorney with 35 years of experience in federal and state environmental law. I helped write much of the legislation you're claiming gives you authority over private wells. The blood drained from Walsh's face. Murphy just looked confused. And the other thing you should know, I continued, is that everything you've said in this meeting has been recorded by the FBI. On cue, Agent Santos and 3 other agents approached our table, badges visible. Richard Walsh and Kevin Murphy, Agent Santos said. You're under arrest for conspiracy to commit fraud, impersonation of federal officials, and violation of federal racketeering laws. The arrests made front-page news throughout Texas and eventually became a national story about sophisticated real estate fraud. Schemes targeting elderly rural landowners. The investigation that followed uncovered a network of companies operating in 12 states, with combined profits exceeding $50 million from fraudulent property acquisitions. Elena's case became the centerpiece of the prosecution, and her testimony about the intimidation tactics used by Metropolitan Water Solutions helped convince a federal jury to convict Walsh, Murphy, and 6 other defendants on multiple felony charges. The sentences ranged from 5 to 15 years in federal prison. But the most satisfying outcome was the civil settlement that provided compensation to Bayes. Over 300 families who had been victimized by the scheme. Elena used her settlement money to create a foundation that provides free legal assistance to rural landowners facing property rights disputes. 6 months after the Baccarat trials ended, I received an invitation to speak at the National Conference on Rural Property Rights in Washington, D.C. The conference brought together farmers, ranchers, attorneys, and legislators from across the country to discuss emerging threats to agricultural land ownership. Standing at the podium in a hotel ballroom filled with 500 people who had dedicated their lives to BCRA, protecting rural America, I reflected on how much my retirement had changed since that morning when Patricia Hamilton first showed up at my ranch. Ladies and gentlemen, I began, 2 years ago, I thought my career in water rights law was over. I was ready to spend my golden years tending cattle and enjoying the peace of my family ranch. Then some people in expensive suits showed up at my door with documents claiming they had the right to my pond. Laughter rippled through the audience. What I learned from that experience, and from the cases that followed, is that retirement doesn't mean the end of responsibility. If you have knowledge that can help people, if you have experience that can prevent injustice, then you have an obligation to use those gifts, regardless of your age or your plans for the future. The applause was sustained and heartfelt. These were people who understood the value of standing up for principles, even when it was difficult or inconvenient. After the conference, I was approached by representatives from the American Farm Bureau Federation, who asked if I would be willing to lead a national task force on property rights protection. The position would require extensive travel and a significant time commitment, but it would also provide resources to help families like Elena's before they became victims of fraud. I accepted the position, and for the next 3 years, I traveled throughout the United States, training rural attorneys, educating landowners about their rights, and working with federal and state legislators to strengthen protections for agricultural property. The work was challenging and often heartbreaking. I met families who had lost land that had been in their families for generations, victims of schemes that made Patricia Hamilton's pond grab look like amateur hour. But I also met people whose courage and determination reminded me why this work was so important. In Montana, I helped a ranching family fight off a mining company that was using fabricated environmental claims to force access to their property. In North Carolina, I exposed a timber company that was buying farmland based on fraudulent surveys that understated the value of the standing forest. In Oregon, I worked with federal prosecutors to shut down a company that was convincing elderly farmers to sign over water rights in exchange for worthless carbon credits. Each case taught me something new about the creativity of people who prey on honest families, but also about the power of knowledge and persistence in fighting back against injustice. On my 72nd birthday, I was back at my ranch, sitting by the pond that had started it all. Sarah Martinez had driven down from Austin to celebrate with me, along with Elena Vasquez, Tom Bradley, and several other friends who had become part of my extended family over the years. "Miguel," Sarah said, raising a glass of wine, "when we wrote the Rural Water Access and Preservation Act 40 years ago, did you ever imagine it would lead to all of this?" I looked around at the faces of people whose lives had been touched by the work we'd done together. Elena's property was safe, her horses were thriving, and her foundation had helped dozens of other families. Tom Bradley's ranch was protected by the stronger legislation we'd passed. Families across the country were safer because of the task force's work. "Sarah," I said, 40 years ago, I thought the law was just words on paper. I've learned that the law is only as strong as the people who are willing to defend it." Elena stood up, her glass in hand. "Here's to Miguel," she said, "for teaching us that knowledge is power, but only if you're willing to use it." As the sun set over the Texas Hill Country that evening, I reflected on the strange journey that had brought me from retirement to national prominence in the fight for property rights. My cattle were settled for the night, the fence posts were secure, and the world was quiet again. But I knew that somewhere out there, another family was facing another threat to their land, their water, their way of life. And tomorrow, when the phone rang with another cry for help, I would answer it, because that's what you do when you have the knowledge and the experience to make a difference. The pond rippled gently in the evening breeze, and I smiled, knowing that this water, this land, and the principles they represented would be protected for generations to come.